Hello, everyone, and welcome to Hayes' Higher Learning. I am your host, Ashley Hayes, and I am so excited. Today's episode is all about intellectual property, and we're having a conversation on licensing, royalties, and residuals. And I have invited one of my favorite people in the world, my godfather, Ed Lance. So I'm going to give you all an informal bio. I met Ed Lance about 31 years ago. The story goes he was around the day I was born and has been my godfather ever since. And I love our relationship. I love having a bonus parent that I can call for advice. And he's been such a part of my life and my career these past few years. So I'm going to give you his formal bio, and then we'll bring Mr. Lance to the table. So Ed is a corporate attorney practicing intellectual property law at Archer Daniels Midland, a Fortune 100 global agribusiness. Before ADM, Ed spent nearly 10 years at McDonald's Corporation, where he represented the marketing and communications group in the US, Europe, and Asia. Ed began his legal career as a member of the intellectual property group at Kirkland and Ellis LLP in Chicago. He also teaches intellectual property at Loyola University, Chicago. Ed earned 2 undergraduate degrees from Southern Illinois University and a Juris Doctorate degree from Loyola University of Chicago Law School. He currently serves on the board of directors for Youth Guidance and is the former chairman of the board of directors for the Hyde Park Art Center. He and his wife, Tracy, live in Olympia Fields, Illinois, and have 5 children and 4 grandchildren, and of course, me, a godchild. So, hello, Godfather. How
I'm
are
doing
you?
great. How are you?
I am good. It is so good to finally have you on my show. I have waited a long time for this conversation.
Yes, I'm proud of everything you've accomplished, and it really does feel good now being a contributor to it.
Well, thank you. I appreciate that. So I know you primarily as my godfather. And over these last few years, especially since I've been a full-time artist, I've gotten to know you as an attorney. Do you mind talking to me about your career path and how you even ended up in intellectual property law?
I like to tell people that I got here with smoke and mirrors, meaning, it was just meant to be. I never had a plan. It just happened. So out of college, I was going to go to graduate school and then go to law school. But while I was in graduate school, I was bored. I was in graduate school at night and didn't have a job during the day. So I decided to take a part-time job. I took that job at a law firm in Chicago as a clerk. It was an IP boutique firm that represented blue chip clients, and I just wanted to be exposed to the law. So I took that job, and I was the guy who filled the copy paper in the machine and updated the library books when we actually used books to do our legal research, and and took it from there. I was there for less than a year, and I asked to do paralegal work, and they tried to make it seem like I wasn't able to do paralegal work because I didn't have a certificate to do that. But, I convinced them that I was certainly capable. And that's what happened. I started doing paralegal work. And from there, I stuck around a little bit longer than I thought. It took me about 8 years before I actually went to law school after that. But then I went away to law school and graduated law school and ended up at Kirkland and Ellis. So, it's been a heck of a career considering how it started.
Yeah, and it's Kirkland and Ellis where you met my mom?
No, she was at the first firm that I worked at Patterson McAuliffe. We both worked there. So I like the way you said I was just around when you were born. Like it sounded a little weird, like I'm just hanging around the the maternity ward. But yeah, we worked together, and of course your dad and your mom and I were good friends.
Yeah. I mean, like you've been in my life since that very day. So,
Yeah.
one of the most valuable things that you have contributed to my career is you have helped me understand recording contracts and really advocating for me to be paid fair wages. Do you think that artists like myself should invest in retaining an attorney? Are there more accessible ways that owners of small businesses can get help with understanding contracts and understanding their rights?
Investing in an attorney is it's based on your resources, really. So I can't say that you need to do that. unless you can do that. I think it really helps to have that expert on your side, but there are so many other resources. Artists and particularly writers are certainly used to research, right? And if it depends on the type of writing, I guess you do, but it doesn't matter. I think you're accustomed to research, and that's what I think has to happen with artists. I think they have to take the time to do the research in the legal area. Some will say, "Oh, it's confusing. I don't understand it. It's legalese, and I don't understand these terms." But in a way, it is, and in a way, it isn't. There are a lot of resources out there these days that even attorneys use for our continuing legal education requirement. So I stay on top of a lot of this stuff by going out to the resources that I have here in Illinois to watch videos on the latest developments in the law. There's no reason why an artist couldn't watch those videos. They're free. They're online. You just have to do some searching and make sure you go to the right sites and get a hold of them. So there's a lot out there. The Authors Guild is an organization that also has a ton of resources. You have to be a member, and I'm not sure what the membership is, but I'm going to say that it's nominal and affordable, given the wealth of information that you're going to get there. So you don't have to have an attorney, but I tell my corporate clients, they may be in marketing and communications and sales and things like that, but I say that my job is to be sure that that I create just a little bit of lawyer in each one of them, and that they channel that lawyer when they can't reach me, and they have to answer basic questions. So I think artists should be the same. You should know what the difference is between a license and an assignment. Some things we may talk about here today. You got to know those things. You got to be able to talk to publishers and producers and folks that are asking you to sign contracts, and at least be able to spot some major issues in some of those terms.
That's really good to know, the Authors Guild. I will even look into that. I didn't know that. And I like that part about creating a little lawyer, because I feel like you created a little lawyer in me.
Oh, yeah.
And she just shows up.
That's right.
And so, yeah. One of the reasons I invited you to this conversation was your advice was a key factor in my decision to self-publish instead of signing with a popular publishing company. And I remember that after reading the very first sentence, you immediately said, "No, you can't sign that." What language or phrasing triggered that response? And what would the consequences have been if I had signed it?
So if I recall that agreement, it was a publishing agreement. I won't name the publisher, but it was your standard cookie cutter language when it comes to the very first article, which is usually granting publishing rights. And that first line said that you were going to grant and assign exclusively to them each and every right in the work under the laws, right? And so on and so forth. That was a red flag to me right away. Now, that is standard language, I must admit, in publishing agreements. The problem with that, it was twofold. First of all, if you have leverage, which most small, authors, artists, they don't have a whole lot of leverage. So let's just unveil
the transparent about that.
Right?
Yeah.
Let's just unveil that right away. I'm talking pie in the sky when I say you can change these things, but we know that you can't, because the publisher is lawyered up, first of all, and this contract is what we usually call a contract of adhesion, where this is the cookie cutter contract, and they'll tell you we don't make changes. We have to have this contract apply equally to everybody we do business with. So we know that that's not necessarily the case. When you have leverage, you can change language like the author grants and assigns. I had an issue with assigning. Assigning means you are transferring your right in that work to the publisher. And unless you have a term for that, right? If you have a term limit on that transfer, that's fine. That's not usually the case. It's usually for the life of the copyright, right? And the life of the copyright is the life of the author plus 75 years. So we know that that's a long term. The law now also has some language in the Copyright Act that now gives a little bit more leverage back to the author that says after 35 years, an author can terminate and then have those rights revert back to them. But that's a long time to wait. I like to see at least
65, yeah.
yeah, you'll be pretty old, right? The I'd like to see authors at least try to give the publisher a an exclusive license, right? So now they have an exclusive and long term they have an exclusive license that they give to the publisher in the right, and then you start limiting the right to publish, right? The right to publish the work, maybe even the right to display the work and some other things that they'll need when they have to promote the work, the right to distribute the work, right? So you can give them a time limited right as well as a scope limited right. Copyright is broken up into a lot of different pieces as you, the creator, control. So you can give them that right for a limited basis, limited time, limited scope. You can retain then some rights for yourself. And you can then even give them non-exclusive rights to some of the rights you retain for yourself. Some of the key things that I felt was that were problematic for that agreement was it included that you were assigning to them the right to perform the work publicly, the right to display the work publicly. Well, what then have you kept for yourself? There was nothing in the contract that said that the artist will retain certain rights, and including these that I just mentioned. So that meant that you, as the author of that work, would have to go back to them to get a license to perform it. That's not tenable. That's not something that I think authors and artists should find themselves tied down with. But again, it comes to leverage. If you've got your first piece of work and you've got a publisher that's interested in purchasing that right or having those rights transferred, you're likely going to go ahead and sign the deal. You hear a lot about how musicians and songwriters just got totally taken when they signed deals like this. Well, that's because they were eager to get that first deal. So I'd like to tell authors to be patient. And if you don't have the leverage, you don't have the resources to get a lawyer to create at least a fair fight, think about walking away from a deal like that. It's hard to do. I get it. I'm not going to pretend that I don't get it. You're writing and you're not just creating art, you're trying to create art that you can distribute to the masses. And that's what a publishing agreement allows you to do. A publishing arrangement allows you to do. So I get that part. But to the extent that you can get some of this language changed, try to get it changed. And here's the thing. If you're going to assign exclusive rights to a publisher, at least limit the scope to those things that they need in order to produce the book. So the right to reproduce the work, the right to produce the work to begin with, distribute the work, display the work. But the right to perform publicly was one of those things that I think as we negotiated with them, we gave up a little bit and said, look, if we're going to transfer this right over, it won't be as it said in the contract, each and every right in the work under the law. No, it's not. We can't do that. So we try to limit the scope, and you being as smart as you are, learn that it's at some point you have to walk away from a deal so that you don't hurt yourself down the road. And I can just say anecdotally, I've seen a lot of artists give up their rights because I've been on the other side of these deals. When I was with big companies, particularly McDonald's, where we did a lot of agreements with talent, we insisted on owning what was created. But we weren't a publisher, but as a company that hired artists to do work for us that we then used in advertising and promotional things, we wanted to have all those rights. We wanted to be able to say that this is ours. Well, that's a work for hire arrangement, which is a little different, but it's something that I've insisted on when I'm on the side of the company.
Mm-hmm. But I would also say that in that position, right, the company is offering some, I guess the term is consideration, right, for those rights. What consideration would have made this particular agreement more fair? Do you think that there's a fair amount that a company can pay for these rights?
That's a good question. So I hate when people answer and say that's a good question. That's the $25,000 question, and not in relation to what is fair compensation, but that's the critical issue. That's the critical issue. But it's two parts to that and to my answer. A, I
Mhm.
think that there's always a dollar amount where you will say yes, right? I mean, because the reason you're even considering this deal is because, again, you want to get your work published, and you want to get that work published and distributed to the masses. So if you self-publish, there's some cost associated with that. There's some there's some inexperience that you bring to that. There's some efficiencies that the publisher brings to it that you don't have. So there's reasons to say yes to a deal like this where you're going to assign your rights. So I say that you try as much as you can to run that number up as much as you can, as high as you can. Those percentages on the royalty, the advance, right? You can try all of those things if you're going to assign away your rights. But the second part to that is there may not be a dollar amount that makes you walk away from the right to your work. That's your baby, right? That's your baby. You're giving that baby to the publisher and saying, it's now yours. I can never, ever exercise a right unless I come back to you to perform that work and to do other things with that work. And what price do you put on that? That's what a lot of artists don't really think about. What happens when that one poem you write that then is published by this publisher that strong armed you, if you will, into assigning away all rights in the work, and then that piece of work becomes your seminal piece of work. It's the thing that people know you by. And now you go to a concert or you go to a slam or whatever, and you can't perform it unless you get a license back in that publishing agreement, which is one of the things you can do. You've assigned the right to them, and you get a perpetual, probably non-exclusive, but a perpetual license to perform the work royalty free, right? So you don't ever have to pay them. You don't have to come to them for notice. So there are ways to get it, right? So you can give them the right, full right, and they own the right to the work, but then you get a license back. That if you're going to do that, then that at least gives you the right to perform your seminal work in perpetuity. But they're going to be the ones getting paid on that. That's the one, when you're performing it, that's good for them, because you're going to say, go out and get my book. And that book is going to go, that book is being sold by that publisher. Of course, you're getting a royalty, so sales benefit you as well. But just know how that all will work when you sign an agreement like this. And the consideration is important. The compensation is important. And you need to know exactly what your value is. And you can do that by consulting with folks like the Authors Guild, and if you can, get a lawyer or an agent, literary agent, who can represent you. But there is a dollar value that may actually lead to you giving up full right in the property.
And that was my issue with the agreement. Once you pointed it out to me, I said, what if I wanted to make Smoke a short film, or if I wanted to make Smoke a long film, or if I wanted to break it down and sell the pieces or create a short story? Now I have to ask them for permission to use work that I created.
Right.
And that just... It just
now they may,
and so
they may say okay to that, because they actually want to capitalize on your creativity, right? But in that situation, they're licensing you to do that, right? So they're actually going to benefit, and I think that that's smart. But they may also say, thanks, we don't need you to do the derivative. We want to turn this into a short film, but we don't need you to write it. We're going to have somebody else write it, and they don't need your permission, because they actually have the right to create derivative works. That's that's in the scope of rights that you've now signed away when you say each and every right in the work is being assigned to them, right? So just know that. So it's important that, but they could come back to you and say, we want you to do that. So, but they may not.
You got to consider that. And so oftentimes, from my experiences, people tend to be kind of hush hush about agreements. And so people don't always know what's fair. Do you think there are ways to increase transparency in the industry? Do you think that that's a good idea? And if so, how can artists ask for transparency?
In this particular case, I think that artists, again, without a whole lot of leverage, will not get a whole lot of transparency. When you start asking a lot of questions and start talking about my lawyer said, these publishers are not going to be all that responsive. They're in a volume business. They're actually trying to get that artist who doesn't have a publishing contract but has some talent, right? That's who they want. They want to be able to sign somebody who does not have any experience with having published before. So they don't have they don't have a reason to be transparent. So you have to do certain things that kind of cause the transparency. And this is sort of my way of making it a little more fair. It's not something that I think is going to always be successful. But you have to ask for the written agreement well in advance of whatever the timetable is that they set. Right. So it's none of that. Here's the agreement. We need you to sign it by the end of this week so we can get started. Right away you say, I'm going to need a little more time than that. My family's lawyer needs to look at this. My family and my lawyer needs to look at this or whatever, but even if that's not true, that's your intent, is to try to find a lawyer to look at it. Right. So I'm going to need to extend that time. If they say that's not going to work for us, then you're dealing with a publishing company that's really only interested in taking advantage of folks who are new to this situation. The other thing is I've tried this; it doesn't always work. When I was on the big corporate side, I was not always successful either. But don't send me a PDF of our agreement. I think you've heard me say this many times, and everybody, my clients hear me say this now, even at big corps. An agreement is between two parties. No one owns the agreement. It's actually jointly owned. What happens is the big player usually is the one that controls the creation of the document. And that's how you know who has the most leverage right away, because when they send you a PDF, and you say, I need this in Word so I can make some changes, they say, oh, well, our lawyer doesn't allow us to send this out in Word, our agreement out in Word. And I push back and say, you're right. It is our agreement. It's your agreement and my agreement. So I want it in Word. Please send it to me in Word. Now, of course, I'm usually very nice about it and cordial and trying to convince people and persuade people. But my tone at the end of the day is really forceful enough so they understand that it's not your decision whether or not you're going to send this to me in Word. It's something that we require. And if you and by the way, when you ask the question, well, why is it that you only want it in PDF? And most people, the business side, they may say, well, I don't know, it's just our lawyers just insist on it. I say, well, it seems to me that you're not allowing the best format for me to make revisions that are fair and that are in my favor, versus having this one-sided version of this document that I can't modify, at least electronically. And to be honest with you, it's not something that we should have to do. If we receive it in PDF, I shouldn't have to print it, write on it, or open it up and get in the comments and put comment boxes all over the place. No, I want to strike out a word and type in the new word, right? So it's more efficient that way as well. But the publishers are going to insist on, and producers are going to insist on it being in the PDF because it discourages changes. So that's one way to make at least the process a little more fair. Of course, the other way to make it fair is, I tell people all the time, leverage is something that crosses all platforms and all walks of life. You need leverage. And the way you get leverage in this scenario is to have options. You have to have options.
Competition.
You have to create competition. Even if you're, faking the interests of another suitor, you have to at least make it seem as though this is not the only option you have. And it's better, it's real leverage and not bluffing, if you actually have other options. And that doesn't mean that it has to be a viable option. If you have one publisher and we're talking about usually some smaller publishers. We're not talking, if this is Michelle Obama, she's not going to any publisher. They're all coming to her. So that's not the scenario we're talking about. That's true leverage. But when you're talking about smaller players, smaller publishers, and little known or unknown authors, then you, the author, you have to create the leverage. You have to have this planned out all along. You write something that's impactful and something that people like right away. As you compile that work, start talking to publishers. You may not even be ready to put a compilation of your work out, but still start talking to publishers, understand the process. Because now when you do get ready, you have relationships. You've got two publishers over here in California, you got two over here in New York, you got two down in Georgia that you've talked to along the way. My book is now ready. I'd like for you to look at it, right? Now you can at least say, so it's 5 out of the 6 pass. The 6th one is interested. At least you can say truthfully, you know what? It's with 5 other publishers right now. I like what you're doing. I like the way you came out, with the offer. But let me at least get back to these other 5 and see it. Let me tie up those ends before we start talking about, terms. And even then, when when they send you that draft in Word versus a PDF, you look at it and you say, I can live with these, I can live with this, I can't live with that. You send it back to them. And you're not making any commitments. You're not signing a letter of intent or a memorandum of understanding or some other, document that at least ties you into having to negotiate with them. And if you don't like that deal, you walk away from that deal. That's what I say. Now, it's not my, I'm not the one that has to pay the light bill, right? I'm not the one who has to get the groceries. So I think that you get as much advice as you can, and then you make a smart decision, whatever decision works best for you. But I do caution artists, be careful not to give away your rights for in perpetuity if you can avoid it.
That is such valuable advice. And it's not only valuable in publishing, it's just valuable in life. We're constantly in agreement with each other and agreements with people. They need to be our agreements, not something that you've decided and that you get to own, And I really appreciate you saying that, and people getting to hear you say it.
Yeah.
And I have a question. This is a personal question for me. What advice would you give someone who's thinking about going to law school in the current economy? And do you recommend it as a viable career option?
So I'm going to have to admit that I don't know the cost of law school right now. So it's going to be difficult for me to talk about it in the current economy, because that's what matters. How much is it going to cost to go to law school versus if I don't go to law school and continue down the path I'm going, am I actually going to still make pretty good money and don't have to, and I'm not saddled with debt, law school debt, unless you're paying for it, or some parent or grandparent is paying for it. So but I will say it this way: I don't think this changes from generation to generation. An investment in your education is always a good investment. I'll take it a step further and say, as I now know, a kid from the South Side of Chicago who came from nothing and went on to college and graduate school and law school, that had I not done that, I would not have had the options that I have. I started this off by talking about doing this with smoke and mirrors. The smoke and the mirrors really have been those pieces of paper that I earned in college, an associate's, a bachelor's, spending some time in graduate school before going to law school and getting that Juris Doctorate. When you are armed with that type of ammunition, if you will always have what you need to fuel your career. You will always be employable. There is a dollar amount that maybe makes it cost prohibitive for some. But I will say that, but I would say that, a law degree is an education that applies across a lot of platforms. The analytical ability that you have, the strategic thinking, the critical thinking, you can apply that to banking. You can apply that to education. You can apply that to not-for-profits. It's just the type of degree that is applicable no matter what your career choice you make. So I've encouraged people to do just that. To go out and if you don't have to want to be a litigator to go, your goal is to get the law school education. Doesn't always have to be, the end goal doesn't have to be to become a litigator or become a lawyer or to become a licensed attorney, right? Just the education alone puts you light years ahead of some of your competition when you're looking at, establishing a career. It is an extremely valuable and useful tool that you should have if you can afford it.
Okay, that's helpful. I hear that there is an intellectual property attorney over at Loyola that I might know. So I've been thinking about it. I've
Yeah.
been thinking about maybe auditing one of his classes and see if I want to go that route.
Yeah, he's tough though. He's going to ask you a lot of questions. Might be tougher on you.
Yeah, it might be tougher on me. That's okay. I think I can handle it. I think I can take it. Well,
Yeah.
thank you so much, Godfather Lance Esquire, for having this conversation. It has not only been so valuable to me, but I think it'll be valuable to my listeners who are creatives and who are trying to figure it out and who aren't necessarily dealing with big companies. This is supremely valuable, and I appreciate you being here.
Oh, you're very welcome. Thank you for having me, and good luck to you and all of your listeners.
Thank you. I appreciate it. So, you can follow us at Hayes' Higher Learning. Make sure you check the Instagram page. I'll not only be putting some of the gems that we got today on the page, but I'll also put out some graphics that detail the difference between like a license and an assignment so that you all can have tangible information. That's what Hayes' Higher Learning is about. I did not think of a song of the week, so I will put that on the web page. But thank you all so much for tuning into Hayes' Higher Learning. We're together. We are learning better, doing better, and being better. You all have a wonderful week.